Welcome back. Throughout this course, we've been talking about America's Constitution, written and unwritten, and about constitutional law. But what exactly is a constitution? What is constitutional law? At root, one idea, at least, is that constitutional law is about how the government is constituted, how it's arranged, how different entities and organs of government power operate and work together. So if you ever meet someone from Britain, for example, don't say that they don't have a constitution in Britain. They'll take offense at that. They do have a constitution. It's just not a written one the way ours is. They don't have a single terse text that puts in one place the basic ground rules about how the society is to be governed. But they do have an unwritten constitution, a series of customs, traditions, practices, institutions that have accreted and evolved over the centuries, defining basically their system of government, how government is constituted in Great Britain. They have an unwritten constitution, and so does America. But the challenge in America is we have not just unwritten traditions and institutions and folkways about how our system works. We also have the written one, this terse text that I keep alluding to from time to time. And so the challenge for us Americans is to try to figure out how our unwritten Constitution fits with the written Constitution. And in this lecture and the next one, I'm going to focus on how government power is generally constituted, how it's configured. We've already talked a little bit about the presidency, and the big idea is that the presidency, its powers, its structure, its constitution, if you will, is defined not merely by what the terse text says, because it's not very specific in certain respects about the presidency in Article 2. So it's not merely defined by what the terse text says, but by how the presidency has existed over the centuries, how it actually has operated, beginning with the key precedents set by George Washington early on that gave more concrete substance and meaning to an otherwise slightly open-ended and ambiguous text. We're going to see that the same thing that we saw was true of Washington and the presidency, that there's an unwritten set of traditions that gloss the terse text. The same thing that's true of the presidency is also true of the rest of government. It's true of Congress. It's true of the judiciary. It's true of administrative agencies. In all these cases, excuse me, in all these cases, the text is slightly underspecified. Where it's clear, it controls, but there are places where it's unclear, and where it's unclear, it's actually the practices that gloss it, that fill out its gaps and give it meaning. And so the unwritten Constitution and the written Constitution fit together. The text controls where clear, and where unclear, the gaps are filled by the unwritten Constitution, by actual practice. So let's take Congress, for example. And I'll give you a bunch of examples in this lecture and the next one. Let's take Congress. You might think Congress is a body of enumerated powers. And you might also think that ours is a system of strict separation of powers that very much protects liberty, that in general, you can't be basically incarcerated and imprisoned unless both the House and the Senate have agreed to a federal criminal law, and the president has agreed to actually enforce it. If he doesn't enforce it, basically there's no one to prosecute you. And a judge and a jury both agree that you're guilty. So at least at the federal level, you might think that you have all these separation of powers protections. The House and the Senate have to be on board making something a crime. The president has to agree that it should be a crime and has to agree to prosecute it, in effect, through his deputies, the Justice Department, headed by the Attorney General, and judges and juries have to agree. So you might think there's a strict separation of powers system, generally, at least when it comes to punishment. And you might think at the federal level, and you might think that there are enumerated powers, but it turns out it's not quite so. There are occasions in which each House of Congress can act on its own as policeman, prosecutor, judge, juror, jury, and jailer, all in one, without a statute. Each House of Congress can conduct, for example, oversight hearings and oblige people to come testify. And if they don't, those persons can, even if they're private citizens or government officials, can be held in contempt, which means that they can actually be incarcerated, detained by the House until they answer the questions, and even more. For certain offenses that are committed, whether by a private person or a government official, against each House claims the authority, and has done so since the founding, to adjudicate, to prosecute, to charge a person with a crime against the House, like bribery of a House member, bribery of a Senate member, or attempted bribery, to charge that person, to adjudicate for itself the crime, and to hold that person in prison, basically in a dungeon, in the House or Senate building itself, at least as long as the House or the Senate, respectively, is in session. And that's kind of mind-blowing. It's an exception to the general separation of powers idea, to the general idea of enumerated powers, because the text doesn't say that in so many words. It doesn't say any of that. And yet, that's clearly established in our system. Now, the text can be read to permit this, and if it couldn't, then we'd have to say this practice is just unconstitutional insofar as it breaks with the terse text. You can say that inherent in the power of the legislature are certain oversight and investigation functions, the power to summon witnesses and oblige them to testify truthfully, and to prosecute certain offenses against each house. You can say that's just inherent in the being a legislature. And you can say Parliament, the English Parliament, had those powers. And many state constitutions had state legislatures at the time of the founding. And at the time of the founding, these state legislatures claimed these inherent powers even when they weren't specifically mentioned in the state constitution. So you could say, well, at the time of the founding, Parliament could do this, state legislatures could do this, but Parliament is a sovereign body. It's not a creature of enumerated powers at all. It can kind of do almost anything it wants. It's the proverbial 800-pound gorilla that basically does whatever it likes. And state legislatures, again, many of them were not creatures of enumerated powers, and there's a less strict separation of powers system at the state level. For example, certain things might be state law crimes, even though the legislature didn't create a statute. Just judges recognized certain things, state judges, as state crimes. That's not true at the federal level. There's no federal crime unless the legislature makes it a crime. Federal judges on their own can't create federal criminal law. State judges, in effect, can. So if we just had the text of the Constitution and these earlier examples of state legislatures and Parliament, we could say, well, the federal Constitution is stricter. It's got a stricter system of enumerated powers. It's got a stricter system of separation of powers. So Congress doesn't have these inherent powers the way state legislatures might or Parliament might. But that's not how it's played out. From day one, each branch of Congress has claimed these broad powers, and these broad powers have been recognized and confirmed by the other branches of government. So, for example, very early on, both the House and the Senate claimed the power to hold oversight hearings and to compel people to testify when they thought there was maybe some problem that needed their attention. And almost anything that could result in legislation can be the subject, or even could result in a possible constitutional amendment, can be the proper subject of a congressional investigation. Early on, there were questions about the financier of the American Revolution, Robert Morris, and whether he had engaged in financial improprieties. So he actually asked Congress to hold hearings on that, and the House of Representatives did, even though, again, there's nothing specific that gives it the power to hold hearings. When there was a botched military expedition early on under President Washington by General Arthur St. Clair, the Senate held oversight hearings, and again, this was accepted as their power. They could subpoena witnesses and force folks to testify, and if people didn't testify, they could be held in contempt, incarcerated, literally held until they were ready to answer. And more than that, early on, there was a fellow named Robert Randall, and he wasn't a witness before Congress. He was just accused of having bribed a Congress member early on. And so when this allegation came to the attention of the House of Representatives that this fellow Randall had attempted to bribe House members, they basically used their officers, their sergeant-at-arms, to grab Randall, bring him into the House of Representatives. They held a trial. I think it lasted 3 days. At the end of the trial, sitting as, in effect, a court. They just turned themselves into a court. They prosecuted, they grabbed him, kind of as a policeman. They prosecuted him on their own, the House of Representatives. They sat as judge and jury and, in effect, convicted him. And then they threw him in the dungeon. There actually are prison cells in the Capitol building, and they held him there for a week. And they've claimed the inherent power to punish for certain contempts of Congress. Each house has claimed that power. The Supreme Court has unanimously upheld this, a case called Anderson against Dunn, going all the way back to the Marshall Court era. 20th century courts have repeatedly reaffirmed this power. Courts might think that the person is innocent, but they don't release the person just if the House prisoner claims he's innocent and the court agrees. They basically say, as long as the House or the Senate acted within its jurisdiction, we're not going to second-guess the judgment. So what are the rules? Well, no one can be held for longer than the House or the Senate is in session. It has to be for a violation of you have to be charged with some crime against Congress itself, like bribing a House member or lying before Congress, something like that. The prosecution can't violate the Bill of Rights, so you can't be punished merely for speaking out against Congress. Presumably you're entitled to certain fair procedures, to have a lawyer present and other things, but as long as each house basically kind of acted as a court and acted only within the area that involved the jurisdiction of the House or the Senate as such, then you can do it. And again, the text doesn't say so, but our practices do. And the text is somewhat ambiguous on this. This is understood as an inherent power of the legislature. The legislature can't perform its function unless it can find out what's happening in the world in order to legislate intelligently. So that means it has to have very broad oversight power, the power to summon witnesses and get them to give Congress information it needs. And it has to have the power, apparently, on its own to prosecute crimes and offenses against it. It shouldn't have to rely, the thought is, on courts or on the executive branch to do this. So America's written and unwritten Constitution cohere in a way. The written Constitution can be read different ways, and these early practices definitively determine which way the text, actually the ambiguous text, is read. Let's talk about vacancies in the three branches of government. So what happens, for example, if there's a judicial vacancy? Well, the Constitution says that the president has power to fill certain vacancies that occur during, let's imagine the vacancy occurs when the Senate isn't in session. Because ordinarily, the president would nominate a judge and the Senate would confirm the position. But what happens if the vacancy occurs when the Senate isn't in session? It's a cabinet vacancy or a judicial vacancy. Well, for a cabinet vacancy, you could say, well, the president needs his team in place. He gets to put someone in temporarily. And there's a specific clause, the recess appointment clause, that says that the president, during a Senate recess, can temporarily put someone in if the Senate isn't in session. But if we were just looking at the text, when it comes to judges, that would be a little awkward, because on the one hand, there's this recess appointment clause. On the other hand, judges are supposed to serve for good behavior, in effect have life tenure, have a certain kind of independence. And they wouldn't really have complete independence if they were basically only provisional or probationary judges. They would be in power until the Senate reconvened, but then the Senate would be free to not confirm them for the position and to, in effect, toss them out. And the Senate might do that because the Senate was displeased by their early rulings. So it's slightly awkward to allow these recess appointments for judges, because that doesn't really fit so well with the idea of judicial independence. And if we just had the text in front of us, we might say, okay, well, there's the recess appointment clause, and there's the idea of judicial independence. We can have them both under the following practice, that if the president picks someone to fill a temporary, to fill a recess, a vacancy, to fill a vacancy, that's occurred during the Senate recess, the person should serve just during that recess. They shouldn't really be eligible to fill the slot permanently. And that way, if let's say there's some very senior statesman or something, and so they fill in, the cases get decided, we've got the judges in place, but they are not really kind of up for the permanent position, so they have, in effect, complete independence. Because they're not going to have to worry about whether they're going to get confirmed by the Senate or not, because they're not even up for that. They're not deciding cases, looking over their shoulder at all time, worrying about how the Senate will think about that. So that's probably the best interpretation of the Constitution on a clean slate, but that's actually not the rules of the game today. And that's because the Constitution can be read in other ways, and in fact, it has been read in other ways. And from the beginning, from George Washington on, presidents have picked judges and put them on lower courts, and actually, until recently, on the Supreme Court, temporarily, while the Senate was in session, and these people actually, these judges, decided cases before they had been confirmed by the Senate, and the Senate was free to either confirm them or not. And actually, in one case, early on, the Senate didn't confirm the recess appointments. And so it was clear early on that these probationary judges didn't quite have the full independence of other judges, but nevertheless, our system has in its actual operation, in its practice, in its kind of British-style constitutional configuration, our system has basically recognized the legitimacy, the lawfulness of these recess appointments to the judiciary. Now, what happens when there's a vacancy in the Senate? That's a little easier. You hold a new election for the senator, and before that election, the governor can temporarily name someone if authorized. So vacancies for the Senate is not so complicated. But what about the House? And in particular, what about the very first meeting of a new House of Representatives? Because the House of Representatives, in effect, dies every 2 years. The Senate is a kind of ongoing, continuous body. At any given election, only a third of the Senate basically is up for election. 2/3 just carries over. It's a staggered system. So everyone serves a 6-year term, but only a third of the senators are up in any given 2-year interval. And so at the Senate, basically, they're always, in effect, typically two-thirds of the senators in place to swear in the new senators who have been newly elected. So that works pretty smoothly. But what about the House of Representatives? There's a 2-year term. At the end of every 2 years, the old House dies and a new House is elected. At least formally, on day one, no one is a House member before anyone else is a House member. No one carries over. There's no continuity. Even someone who's been Speaker of the House for 20 years, on day one of the new Congress, that person is just the same as a newly elected freshman House member. And the interesting question is, well, what happens if there's a question about whether someone was properly elected or not, whether the election was fair? Remember, each House is the judge of its own elections. But what happens if there's a question about some House member? Well, if there's 1 or 2 or 3 contested elections, everyone else is sworn in, and those people are sort of stand aside, and that works. But what happens if there's a challenge. So ordinarily, this question of what happens on day one in the House of Representatives is a little bit theoretical. But during the Civil War, it was anything but theoretical, because there were a question about a whole bunch of members of would-be members of the House of Representatives who came from the states that had purported to secede. And in 1865, they show up and say, "Okay, we're back. We're ready to be seated in December of 1865." And the others say, "Not so fast." But on day one, you see, who decides who gets sworn in on day one? Who decides who decides? Who decides who decides who decides? It's kind of an infinite regress problem in theory. And the Constitution doesn't quite specify how all that will work out. Now, you could say, oh, here's what should happen. The old House of Representatives, the outgoing one, should basically sort of set up a system for adjudicating questions for the incoming House. But from a formal point of view, the old House of Representatives dies. It's like Cinderella, at midnight, poof, the gown turns to rags and the pumpkin, the coach turns to a pumpkin, the horse turned to white mice. So from a strict formal point of view, at the strike of midnight, the old House doesn't exist anymore, arguably. You could say, oh, well, the Senate should oversee this, and because they're a continuous body. They're sort of like the big sibling of the House. In the same way that judges help pick jurors, the Senate can kind of oversee the selection of the new House. But the text doesn't say that in so many words. You could say, oh, well, the president should really do this because he's on the job 24/7, 365. He's always in office. That's a structural idea. So he should do that. But do you want the president really deciding who is really lawfully in the House or not? That seems a little awkward. So if you just looked at the Constitution's text, it's not so clear what should happen. Should it be the old House? Should it be the Senate? Should it be the president? In fact, in the Civil War, what happened is, actually, foreseeing that this might happen at the end of the war, the Congress, during the middle of the war, actually passed a statute in which the House, the Senate, and the President all basically came to an agreement. And the agreement was, on the first day of a new House, the clerks, the ministerial officer of the old House would sit in the chair at the beginning and decide whom to recognize and not. And so really, it's the old House kind of lingers a little bit in order to help select its predecessors on day one, but it does so thanks to a statute that all three branches agreed to, the House, the Senate, and the presidency. This statute, there's nothing explicitly in the Constitution that provides this solution, but it's basically how our unwritten Constitution has filled in this very weird and peculiar gap in the written Constitution, which is, how does each House of Representatives at the beginning of a new congressional term, every 2 years, how does it bootstrap itself into existence? How does it jumpstart itself? How does it get going? How does it give birth to itself? And theoretically, it's a real problem, but as a practical matter, it hasn't been, because the branches during the Civil War came up with a very clever solution that has been in place ever since. It's part of our unwritten Constitution that supplements and complements and completes the written one. Okay, those are a couple of examples. In the next lecture, I'm going to give you a few more. We're going to talk about what decision rule operates within each of these branches. Should it be majority rule or supermajority rule in the House, in the Senate, in the judiciary? So we're going to talk about, for example, filibuster reform in the next session. And I'm also going to tell you, as I always do, about the pitcher. So can you figure out who this fellow is and what he has to do with what we've been talking about? I'll tell you at the end of the next lecture, so stay tuned.